severance, Jim.
We'll now consider our final case. Let's let counsel have a chance to gather up materials first. PROLOGIS creditor versus Michael, is it MOECKER?
Keith.
All set?
Thank you. May it please the Court. I'm Patrick McGee. I represent the landlord, PROLOGIS, in this appeal that arises out of a Chapter 727 proceeding, commonly called an assignment for the benefit of the creditors. PROLOGIS's tenant Stems executed a Chapter 727.
Before you get launched too long into this, is this a final appeal or not? I mean, do we have jurisdiction over this case or not?
Well, we've asserted that it is. Of course, this court dealt with that before the briefing schedule.
And what we said was brief it, and we'll take a look at it later. I think it's the motion thing. Yeah. Well, this is later. So why is it that we have? I mean, is there anything else to be done on the how do you say it? PROLOGIS?
PROLOGIS.
PROLOGIS.
How they pronounce it.
On
Yes.
the PROLOGIS claim.
There's nothing else to be done on PROLOGIS's claim. There was a final determination of what PROLOGIS's claim would be in the estate. Following in the estate, remaining to be done, would be the final accounting.
Did this order do that, or was there subsequent activity in the case that ultimately determined your claim?
Our claim is already determined, so there will be subsequent.
My question was, was this order the final order that determined your claim, or did you subsequently have to have other orders entered that reduced the claim, or that do you understand my question?
I think I do, and this is not an ordinary procedure, I think, for the court or for us, but the order was a final determination of the PROLOGIS claim. PROLOGIS filed a proof of claim. There was an objection to a limited portion of the claim, a portion of the administrative rent.
The amount that had been taken from the letter of credit.
That was the argument, is that we'd already been paid that portion of the claim. So in that regard, there's nothing else to be done to determine the amount of the PROLOGIS claim. That will be plugged in later when the estate is closed, distributed, so forth. But in that regard, there's nothing that remains to be done. Of course, what we're dealing with here is the objection to that portion of PROLOGIS's claim that sought administrative rent according to Chapter 727. And under that particular statute, it was MOECKER's obligation to pay rent. To put it another way, 727(1)(b) under that statute, PROLOGIS was entitled to payment of the rent incurred by the assignee MOECKER in occupying any premises in which the assets of the assignment estate are located.
For what period of time?
The time period is from and after the date of the assignment through the date on which the lease for such premises is rejected pursuant to an order of the court.
And when was that?
Well, at the request of MOECKER, time frames to begin with, the assignment was executed at the beginning of May 4th, 2010. And then MOECKER on June 10th filed a motion seeking permission to reject the PROLOGIS lease, conditioned upon MOECKER's sale of the assets of the estate on June 25th. Sale occurred. The rejection was approved effective June 30th. So there was just shy of 2 months.
You had a letter of credit which covered at least one full month and about half the next month, right?
That's approximately right. Yes.
So I guess I'm having a really hard time figuring out why you shouldn't only receive just the half month's rent that you didn't get out of the letter of credit.
Well,
I mean,
Let-
your rent's been paid.
Let me start back and deal with what the security deposit is and the assertion that PROLOGIS has already been paid for that rent. I
I
think
just asserted that.
yes, and when we're dealing with that issue, I mean, I would ask the first question: well, who paid PROLOGIS the rent? Whose assets were diminished to pay rent during this period of time? Were any of the assets of the estate diminished to pay the rent? No, they weren't.
What would happen if they paid the rent? What would happen to the letter of credit?
If MOECKER paid the rent?
Yeah, what would have happened to the letter of credit if they just started off by paying the rent and not worried about the letter of credit?
I think we would have a timing issue to begin with, and let me set the context. And I think a very important factor here is that this assignment for the benefit of the creditors was executed May 4th. The case was filed May 6th. PROLOGIS was not notified, like other creditors, of the filing of the case at that time, not in May, and it wasn't until June 10th when a motion to reject PROLOGIS's lease was PROLOGIS first notified that there was an estate. During this time, that's when PROLOGIS drew down its letter of credit.
Let's assume the rent was paid. Okay. But not through the letter of credit, but I mean Mr. MOECKER or his clients paid it. What happens to the letter of credit at the end of the lease term?
The letter of credit stands as security for the other amounts that are owed under the PROLOGIS lease.
Like what?
For example, the rent that was due in July and August and September.
Well, let's assume now, because we know that the lease term now ends June 30th. Suppose your lease term ends June 30th. At June 30th, what happens to the letter of credit?
Let me be clear about something. The lease does not end on June 30th.
It's rejected as of.
But that's when MOECKER's obligation, that's when the estate's obligation to pay rent ends.
Right.
So on the one hand, you have the lease obligations of STEMS. STEMS has a letter of credit that it had posted at the inception of the lease. Sure. Under the lease terms, paragraph 5, that letter of credit is not an asset of STEMS, it's an asset of PROLOGIS. At the end of the lease, assuming that the tenant is not in default of the lease, then PROLOGIS specifically is in a debtor-creditor relationship with the tenant. As a debtor of the tenant, has an obligation to repay any portions of the security deposit.
STEMS would have got the money back.
Pardon me?
STEMS would have gotten the money back.
STEMS would have gotten the money back had the remainder of the lease been performed, had there not been any other defaults under the lease. Of course, at this point in time that we're talking about, STEMS had assigned all of its assets and had no means of paying rent beyond that which the estate was obligated to pay under Chapter 727.
But it's your position that the lease continued as to STEMS?
Absolutely, it did. The lease provides for how an assignment of the lease would occur. That didn't happen. The only thing that did happen was that the statutory assignee took over effective possession of the premises upon the execution of the assignment for the benefit of the creditors. When that happened, that didn't extinguish the lease. When MOECKER asked the court to allow the Chapter 727 assignment estate to reject the lease, that did not extinguish the lease. There's a limit to the types of claims that could be made in the estate for rejection of the lease, but that does not absolve the tenant, STEMS, from its obligations under the lease as well.
Did MOECKER vacate the premises as of June 30th?
Yes, I will say yes. What actually happened was MOECKER sold the assets to another party who took over possession. We have other claims, other lawsuits that aren't part of this lawsuit regarding that particular tenant. But MOECKER's obligations are set forth within the four corners of Chapter 727, and it would.
And what happened? Did your client get payments from anybody then after June 30th?
No, we did not.
But somebody continued to occupy the premises, or the premises came back to your client?
Well, not being part of the record, but the buyer of the STEMS assets occupied the premises, and then we had to file suit to evict that party from the premises for not paying us rent. At the end of the day, getting back to who paid us rent, our assertion is that no one paid us rent. That there was no asset of the Chapter 727 estate that was diminished in any way to pay it.
When you took money out of the line of credit, what was the purpose of taking it out of the line of credit?
It was to cover the damages that PROLOGIS had incurred as a result of the non-payment of rent by STEMS, its tenant.
The damages being the rent or something else?
It would be equivalent to the rent, yes, it would. And then under the lease,
the triggering event for you to draw on the line of credit was the failure to pay the rent.
Yes, Your Honor.
What you pulled out was an amount equivalent to the rent payment. But it's not a rent payment, is your argument?
No, I'm saying that no one paid us rent. As we argued in our brief, it is the same as PROLOGIS taking money out of one of its proverbial pockets and putting it into the other. The source of the rent was not MOECKER. It was not the Chapter 727 estate outside of MOECKER. It was not STEMS. It wasn't anybody else except the
Well, but the letter of credit only becomes yours in the event of some action, some default.
Right to draw on it.
That's not what the lease says. The lease says in paragraph 5 that the security deposit is an asset of
Right, so they pay the rent through the entire term. You can just take the letter of credit.
No, the lease provides that at the end of the lease there is a debtor-creditor relationship that is created with respect to PROLOGIS and STEMS, and that PROLOGIS would then have the obligation to pay to STEMS, to the tenant, any unused portion of the security deposit. So, and the lease lays out what the relationship is between PROLOGIS and STEMS, and it's not a trustee relationship. It specifically says that, and that it's also expressly states that the security deposit is an asset of PROLOGIS. So what's been argued in this case down below, and really in the briefing as well, is that the security deposit. There's an argument that there's a CD of STEMS that was related to the security deposit, and that's an asset that was included in the listing of assets below in the Chapter 727 proceeding. But in reality, if that CD was pledged in connection with the letter of credit, and those dots I don't know have all been connected here, but if that was the case, that was not an asset, the CD, that was available for liquidation and distribution in the Chapter 727 proceeding. The creditors in the Chapter 727 proceeding received the same money, the same payment, regardless of whether that letter of credit was drawn down or not. That particular asset was not something available for distribution to the creditors in the Chapter 727.
What does it mean by the lease saying that the letter of credit was the asset of PROLOGIS? If they had to give it back if there were no defaults, they couldn't have used it along, I mean, presumably they couldn't go do something else with it, right? They had to hold on to it till the end. They had to hold on to it to the end of the lease, and they had to turn it back over if all obligations of the lease were met, correct?
That's correct.
Then how does it become an asset of the judge, regardless of what the lease calls it? What's the practical effect of calling it an asset?
I think that removes from the reach of creditors, perhaps has some implications in the case of bankruptcy cases filed, those sort of things. I mean, the point is, the agreement between the parties was that we will post a security deposit, and that will be the asset of PROLOGIS. Let me go back to a timing issue. I know my time is running a little bit short here. I'd like to reserve some for rebuttal. But the timing, I think, is important here. The notion that PROLOGIS, knowing that they had a Chapter 727 proceeding taking place in their premises, then decided, we really don't want to rely on our administrative rent claim. We're just going to draw down on our security deposit right now. That's not what happened. In this particular circumstance, you had no notice to PROLOGIS of the Chapter 727 proceeding, and the implication here is that PROLOGIS waived its right to seek an administrative claim an administrative priority claim in the Chapter 727 proceeding because it drew down on its security deposit. A waiver needs to be a knowing act, and the assertion in the brief by MOECKER is that PROLOGIS voluntarily drew down its security deposit. The implication being that it took action knowing that there was a Chapter 727 proceeding. That's not the case. On the facts of this case, in order for MOECKER to have paid rent, or for anybody to have paid rent, there had to be some act by somebody reducing their assets, increasing the assets of PROLOGIS. There was no act whatsoever that diminished or reduced in any way the assets of the Chapter 727 estate. Under those circumstances, in all real, legal, and practical effect, there was no payment of rent, and PROLOGIS is entitled to be paid rent for the time period specifically stated in Chapter 727. I'd like to reserve some time for rebuttal.
All right. And we'll hear from the appellee.
May it please the Court. Good afternoon. My name is Andy Brumby. I'm with the Orlando law firm of Schutz & Bull, and I'm here on behalf of Michael MOECKER, the assignee in the assignment for the benefit of creditors proceeding below. As you have heard, this arises out of a relatively unusual proceeding under state law, more familiar probably to bankruptcy lawyers than most people. A Chapter 727 action is the equivalent of a Chapter 7 bankruptcy proceeding with a little bit of Chapter 11 twist to it. Here, the assignment proceeding was filed on May 4th. The rent for the proceeding, well, actually the lease, let me back up and make one comment about the lease itself. When you see the record, when you study the record, you'll see that the lease is actually in the name of an entity called Stems Inc., and the assignor below is Stems LLC. There's no dispute that Stems LLC was at least occupying the premises. It's unclear whether or not Stems Inc. and Stems LLC are one and the same, but for purposes of what transpired below and in this court, they are being treated as one and the same. The lease, as you have already noted, contains in paragraph 5 a provision dealing with what's denominated a security deposit, which on the first page of the lease is also denominated as a security deposit and described as a letter of credit in the amount of approximately $72,000 that was the reimbursement obligation from the applicant, which here would be Stems LLC or Inc., whichever one did it, was a CD of their CD and Bank of America that was pledged to secure the reimbursement obligation. When the rent went unpaid on May 1st, the landlord had one of two opportunities. It could start eviction proceedings or it could draw on the letter of credit. Yes, there is a sentence in paragraph 5 of the lease that says the security deposit is an asset of the landlord. I don't know what that means. All the world, in some sense, in this context, is divided into a security deposit or advance rent, money that's delivered to the landlord at a commencement of a lease. The paragraph 5 of the lease expressly says it's not advance rent. A security deposit is just that, security. As you've already noted, in order to draw on the letter of credit, there has to be some event that occurs, and the event that occurred here was a default in payment. As the record reveals, I think, at pages 43 and 433 and 434, if I recall correctly, when the two draws came, first at the month of May and the second in the month of June, the assignee was notified that that a draw on the letter of credit had been had, and he didn't do anything because in his mind that was what was being used to pay the rent. This proceeding involves, in my mind, two questions. The first, the one that Judge Monaco raised, the issue of whether or not this is a final order. Given that the only thing left to do here, assuming nobody further objects and there's no further objections that occur below, is the filing of the final report and accounting and approval of the final report. There's a lot of practical in me that wants to say this is final order. I want to be done.
You earlier moved.
I did.
And you're now saying that was really a bad idea.
Practically speaking, I want to say it's a final order because I want to get to an end. Because I don't want to get back and then have to come back. From a systemic perspective, Your Honor, I have to tell you that I'm not convinced that it is a final order. The statute provides that up until the time of the entry of an order approving a final accounting, any creditor in the case can object to any of the creditor's claims. So theoretically, we could be back again here, even if not on the administrative portion of their claim, arguably on the unsecured portion of their claim, because under Chapter 727, like in a bankruptcy case, a rejection of a lease is considered a pre-assignment breach, meaning a general unsecured claim, and there's a cap on what you can seek. So you do have a pre-assignment unsecured claim to which someone theoretically could object here.
But at least with respect to the issue of whether or not the draw on the letter of credit amounted to a payment of rent for those 2 months, that's pretty much resolved.
Unless somebody else came in and object, I agree. Unless somebody else for some reason
object, since they're pulling the money out of the letter of credit, not
the only reason somebody would object, I can think of 2 reasons or 2 bases upon which the issue could raise its ugly head once again. The first would be if we file the final report in accounting, and this is an administratively insolvent estate. So we're not going to get to unsecured, we're going to prorate at the administrative level. If somebody, another one of the administrative claimants objects for whatever reason.
Is there a time frame on that?
I'm sorry, I'm not sure.
Is there a time frame for the objection?
As I said, Your Honor, the statute provides that any party can object to any other party's claims up until the time of the entry of an order approving the final accounting. And obviously that hasn't occurred yet. We haven't filed the final accounting because we can't until we know what the claim amount is going to be, and we're here resolving that one, at least this time. The second issue, way I could see it come up again, Judge Monaco, would be if PROLOGIS, I may not have pronounced that correctly, PROLOGIS objects to the priority or believes that there should be some different priority for their claim because of what they had to go through, or whether or not they believe the professionals should be subordinated for not agreeing to their claim or some other mechanism which would bring the issue back.
Their claim for the total rent or their claim for $17,000?
If you were to reverse and send it back, I'm sorry. I wasn't clear. If you were to reverse and send it back, they could argue some variety of priority dispute in the administrative claim level. I don't believe the statute envisions any different priority at the administrative level, but one could argue on an equitable basis, I suppose, and see if that worked. So my answer to your initial question to Mr. McGee is, I'd like to tell you, very much like to tell you, that it's a final order. I'm not sure on a systemic basis I can. And I think that's consistent with Bennett's leasing, because as I read Bennett's leasing, another MOECKER case, it says there was still a final accounting and a final report to be dealt with below, and therefore that order in that case, admittedly a very different procedural posture because it was a dispute over who the assignee was going to be, but Bennett's leasing went off on, there was still a final report to do. The second issue and the substantive issue of the administrative rent.
Well, you know, in MOECKER versus Antoine, apparently Mr. MOECKER does all this stuff. In MOECKER versus Antoine, that looks like it's in about the same procedural posture, different facts, of course, but about the same procedural process as the current case. First District ruled on the merits without addressing the subject of jurisdiction. Of course, it may not have been raised there. I don't know.
They did. It is a very close procedural context. In that case, Mr. MOECKER, the assignee, and Mr. MOECKER is one of the 2 or 3 people who do this around the state. Mr. MOECKER had objected to the claim of certain former shareholders who had exercised some rescission rights, and that objection had been overruled, and he had appealed that. There is some dispute in the issue, the order to show cause and the briefs that came out of it as to whether or not the First District ever addressed the jurisdictional issue.
I couldn't tell from the opinion.
I couldn't tell from the opinion, and if you read in the Bennett's leasing opinion, at least suggests that they believe it was never addressed, and ironically enough, Bennett's leasing, I think, arises from the same assignment proceeding as Antoine did. With respect to the issue of the administrative rent, the security deposit, the letter of credit, can't be their property. It has to be the property of the assignor, the entity that, or the reimbursement obligation. Here, it's a little, there's an added twist because of the CD, but what I'm going to posit is this. In an assignment proceeding, you're dealing with, like in a bankruptcy case, a limited amount of resources and a finite amount of debt. Here, if the letter of credit was utilized or drawn down, was there any effect on the estate? Was the estate diminished or was its debts changed? The question becomes, no, there was no change. The debt has effectively been increased because under the appellant's theory, no debt got paid. So it ends up getting paid twice, or with the CD in place, the assets of the estate are diminished by the amount of the CD because there was no benefit. If we pay them a second time, all you've done is diminish the estate with no corollary benefit. That's the first thing. Second, the contractual obligation in paragraph 5 of the lease to reimburse the security deposit. I don't dispute the fact that there was a contractual obligation to do that. Once the lease was rejected, however, that contractual obligation, like any other damage arising from the lease, became a pre-assignment claim. So the contractual obligation would be a pre-assignment unsecured claim, not an administrative claim, if in fact the assignee has to replenish the security deposit that was drawn down, then the general unsecured claim as contemplated by the statute has been converted to an administrative level. The point is, we're trying to share pro rata amongst a finite group of people, a finite group of resources, and do so fairly. Here, the argument is that because they didn't know, they ought to get it twice. Surely that can't be right. They claim they didn't know, so they ought to get it twice. Suppose there had been no assignment proceeding. They get paid the rent, everyone goes on down the road, they don't get to draw on the letter of credit, there's never a default. The only thing that changes here, ironically, is an insolvency proceeding, which somehow entitles them to be better off. That can't possibly be the law. That's certainly not contemplated by the assignment statute.
You don't know how often in the course of the last 9 years I've said exactly the same thing. That can't possibly be the law.
Unless the court has any other questions of me, I don't have anything further to explain to the court today. I appreciate your time and attention.
Yes, sir. Thank you. All right, Counsel, you have just a little under 5 minutes.
Thank you. As to what the law is, we don't need to use our own judgment to figure that out. All we have to do is read Chapter 727 and we can see what the law is. The law specifically, as enunciated by our legislature, says that there's an obligation to pay rent on an administrative priority basis from the time of the assignment of the benefit of the creditors until the earlier of when the lease is rejected pursuant to a court order or the lease expires. So in this instance, the law is what the legislature says it is, and that's what should apply in this case. As far as getting paid twice, let me respond to that. We'd like to get paid once. That would be nice. That's what we're looking for in this case. It's not to get paid twice. And I've looked in the statutes. I've looked in the record that we have here to see evidence that PROLOGIS was paid other than from the security deposit. It was not, obviously. So under these circumstances, the question that we're bringing before this court is a drawdown of a security deposit, whether it was before or after notice of the Chapter 727 proceeding, if that makes a difference, tantamount to the statutory assignee paying rent from the assets of the statutory estate.
Apparently the trial court thought it was.
Apparently so, and that's why we're here. It's rather it's a challenge sometimes for lawyers to bring cases before a judge that have no precedent. There's no case that tells the judge how that should occur, and we have a complicated set of facts in this case, and not a garden variety set of facts. So that's what we were dealing with. One other issue I'd like to address, well, two. In the Antoine case regarding jurisdiction, yes, there was no mention of jurisdiction in the opinion.
Did you find it in there? I didn't say anything.
No, there was not.
It looks like the first district went ahead and made a decision, but without.
That's why we requested the court to take judicial notice of the documents in our appendix, which was the court docket from the first DCA and from the underlying case, which show that there is a virtually identical procedural posture between that case and this. There was an order to show cause issued by the first DCA on this jurisdictional issue. It was later discharged, later withdrawn, and the case proceeded. So the court did not address the jurisdictional issue in its opinion, but it did.
I didn't catch that. Thank you for pointing it out.
But it did earlier in the case. Now, with respect to eviction proceedings, counsel stated that we had one of two choices when the rent was not paid. We could either start an eviction proceeding or draw down on the security deposit, and I would suggest that it's not a choice of one or the other. We could do both. There is an obligation to pay rent. The paragraph 5 says that what the relationships are between the parties, and if the tenant doesn't pay rent and we draw down on the security deposit, we aren't prevented from starting an eviction proceeding. And with the timing of this,
How would you evict at that point if you've covered the rent?
the tenant's obligated to pay rent. The security deposit is to protect the landlord in the event of a non-payment of rent from a cash flow basis or any other circumstance. It doesn't relieve the tenant's obligation to pay.
So if you drew it down enough to cover the month of June, you could still throw them out in the middle of June?
Absolutely, we could. Absolutely, we could.
Would you have to give them back the other half month's rent?
Would we have?
Do you have to give them back the other half month's rent if you evicted them?
We would not. There's an obligation to pay rent until the end of the lease term. And council mentioned that there's no replenishment obligation in the lease. There is. I couldn't find it when I was sitting over there.
Of the letter of credit.
Pardon me?
The letter of credit you're talking about.
Yes.
Yeah, no, I think that there is a replenishment provision.
Yes.
And if there is, you might have a cause of action for a breach of contract for failing to replenish the security deposit, whether or not that would allow you to evict them during a time period where you have chosen to draw down to cover the rent. I have questions about it.
I don't have much time. I know we're dealing with these issues a bit in the abstract, and I understand how this works in the real world. I represent PROLOGIS. I do evictions all the time. Under these circumstances, we would just suggest that the result sought by MOECKER in this case is not within the spirit, the intent, or the letter of Chapter 727. He is obligated to pay rent. He did not do so.
Thank you, counsel.
Thank you. Thank you.
Drive safely home, and nice to have you here. Mr. Brumby, I don't